Hello everybody, welcome to iExamBee's Legal Beat. This is Amrita, your law faculty at iExamBee. In this video, I'm going to discuss with you all another question from Judiciary Mains answer writing series that we have started recently at LegalBee. This is a very beneficial series for judiciary exam preparation exclusively for mains answer writing. हम लोग हर एक दिन एक नया टॉपिक पिक कर रहे हैं फ्रॉम डिफरेंट टॉपिक्स एंड दिस इज़ गोइंग टू बी वेरी इजी फॉर all the students as they are getting sample questions and answers in these comprehensive videos. आप इन PPTs को भी डाउनलोड कर सकते हैं and keep them as a ready reference with you. Take out printout of that PPT and make a record with you. Also, this is a revision for you people on all the commonly asked questions in judiciary mains examinations, which is common for all the judiciary examinations. So this is definitely going to help the students work out and develop their skills in mains answer writing. अगर आपकी कोई भी queries है या फिर आपको किसी question पे answer की requirement है, you can write to us in the comment section of this video and reach out to us. Also at hello@iexambee.com आप इस नंबर पे कॉल करके भी डिटेल्स ले सकते हैं या फिर आप www.iexambee.com पे विजिट करके भी कोर्सेज के डिटेल्स चेकआउट कर सकते हैं. Judiciary Mains answer writing practice series has been started. We have completed 4 questions up till now. The 5th question I will be taking up today, and that is from Code of Civil Procedure. Very important topic. What is the difference between return of plaint and rejection of plaint? Everybody knows about Order 7 plaint. Very important topic from CPC. उसमें से आपको specifically पूछा गया है what is the difference between return of plaint and rejection of plaint. So for that purpose we need to understand and we need to write our answer in such a format that our special focus should be on the necessary elements that are required to constitute return of plaint and also rejection of plaint. Both of them are completely different processes. Starting with a brief introduction that you can give first. Order 7 of CPC deals with what? It deals with plaints. And plaint is what? That also you can add some points on the nature of plaint, that it marks the beginning of a suit. Section 20 of CPC provides for institution of suits, which involves presentation of plaint. Once the presentation is completed, after that the plaint is going to go before the proper officer and it is allotted a court. After that we can say that the suit is duly instituted because all the requirements have been fulfilled. Order 6 of CPC also we can take a reference over here in this answer as it deals with pleadings generally. It deals with the fundamental rules for drafting a pleading. Now what includes in a pleading? Pleading includes both plaint as well as written statement that is provided under Rule 1 of Order 6 itself. जब भी आप कोई मेंस का आंसर लिखते हैं, try to mention certain things which are extra, which are actually relating to the topic only, but they need to be taken reference over it. So that is what is the important thing that we have to check it out over here, that जब भी आप कोई आंसर लिखते हैं तो आपको ये सब मेंशन करना ज़रूरी होता है जो भी रिलेटेड है. Pleadings include both plaint and written statement as provided under Rule 1 of Order 6. Order 7 covers all the rules that are relating to plaint and Order 8 covers all the rules relating to a written statement. अब ये थोड़ा general introduction हमने दे दिया pleadings के बारे में. Now we can come back to Order 7 that contains in all 18 rules governing drafting of a plaint, mentioning all the technical details like name of court, name of parties, all these need to be mentioned in the plaint. What the plaint constitutes actually, now we can focus on that. It constitutes a statement of a claim which is going to reflect the cause of action. What is the nature of plaint? We are elaborating on that again, that it pleads the disputed set of facts on behalf of the plaintiff in court of law and does not include evidence, does not include law points. So it is a fundamental rule of the pleadings only that there should be facts and only facts should be pleaded. Law should not be included as a part of the pleadings. Evidence cannot be incorporated in pleadings. This is also a fundamental rule. There are two very important rules in, that is Rule 10 and Rule 11 of Order 7. Now we can start coming to our point that is the main point of discussion, Rule 10 and Rule 11 of Order 7, which deals with the return of plaint and rejection of plaint respectively. So these depict what situations? It depicts whether the plaint is devoid of jurisdiction or lacks a sufficient cause of action or any other such kind of cause is there. Then the plaint can be returned if there is no jurisdiction. It can be returned for that it is filed before a proper court. And if there is no sufficient cause of action, or if there is some other cause that is persisting, that the plaint should be rejected. That is what is the thing, and that is why it should be mentioned there itself, that these are the reasons. That's why plaint can be returned or rejected as per Rule 10 and 11 of CPC. Now coming to the return of plaint first, Rule 10 of CPC provides for return of plaint. A civil court can order the return of a plaint for presentation to the proper court at any stage, and it has to be checked that the court is competent or not. And if it is not competent by reasons of limitation, what are the limitations? Territorial jurisdiction is not there, pecuniary jurisdiction is not there, then Rule 10 is confined only to jurisdictional defects. This is one thing which we have to remember, कि Rule 10, that is return of plaint, applicable कब होगा? सिर्फ जब there is lack of jurisdiction or there are recourse, there is a jurisdictional error. Then recourse to other court is open for the plaintiff. That is what is the concept of return of plaint. Return of plaint or rejection of plaint काफ़ी different concepts है. Return of plaint is only when the jurisdiction is not there, then the court is not competent to try it. So this should be determined preliminary only, and it should be returned back so that the merits of the case is not affected and the subject matter is tried before the proper court. As we can see, it is discussed, we need to mention case laws also. In the case of RSDV Finance Cooperative Private Limited versus Sri Vallabh Glass Works Limited, 1993 case, when court arrives at a conclusion that it has no jurisdiction to try a suit, then the proper order to pass is not dismissal but return of suit. Always the suit should not be wasted, actually it should be returned so that it can be filed before the proper authorities. This is the simple thing. Rule 10A is also relevant over here as it lays down the procedure that is to be followed by the court upon determining when the plaint is liable to be returned. What it provides basically, that power of court to fix the date of appearance in the required court. The court which is returning the plaint should actually fix a date, because the continuity of the matter is going to break now. That plaint is being returned from that court, so you cannot give that it is disposed, you cannot say it is withdrawn. तो ये कौन से category में जाएगा? So you will be, the previous court will be giving the next date on which the plaintiff can appear before the required court, which is actually having jurisdiction upon it. So आपको यहाँ पर return of plaint को ही stick नहीं रहना है. When you are, I am telling you from the starting, always the correlated topics need to be mentioned. So return of plaints related Rule 10A भी important है यहाँ पे, that you need to mention. As per Amarchand vs Union of India, it was held that the plaint is filed in proper court after getting it back from the wrong court, so it cannot be said to be a continuation of suit, and the suit must be deemed to be presented when it is filed in the proper court. Even for the purposes of limitation, when you are calculating the period, it cannot be considered. This point is very important from that angle also, कि आप इसको continuation suit नहीं कह सकते, because the suit did not actually work there. It was returned, the plaint was returned immediately. Suit तो continue हो ही नहीं सकता. So after that, whichever was the date on which the proper court has taken the first date of appearance, that is the date when the plaint will be deemed to be filed or the suit will be filed. Now, when you are talking about return of plaint and fixing a date of appearance, then there are certain necessary conditions that need to be fulfilled. The mentioning of the name of court in which the suit shall be presented after return, then making a prayer to the court which is the returning, the court which is returning the plaint. You have to make a prayer to that court. Parties have to pray for a date need to be fixed for appearance of parties in the said court, and requesting the notice of the date to be given to the defendant also, because obviously defendant also needs to get the notice that there is a change in the court, so that is something which is obvious. After receiving the application, what the court will do? Fix a date for appearance of parties where the plaintiff is supposed to be presented, give plaintiff the defendant notice to appear in the court. All the things need to be done. That is what is mentioned here. Now let us go to the next topic, rejection of plaint. Order 7 Rule 11 provides for rejection of plaint as well. The provision that is casting a duty upon whom? The court, to reject a plaint. This is what is the duty of the court, okay? But generally what happens, the parties, opposite parties, they move an application for rejection of plaint. This is what is taking place practically. So it is moved in which conditions? Conditions mentioned in clause A to D of Rule 11. If these conditions are there, then a plaint can be rejected. So point wise these conditions we will be discussing. Suppose there is no cause of action disclosed in the plaint. ऐसा कोई proper cause of action disclose ही नहीं हुआ है, so obviously the plaint is liable to be rejected. And this is very commonly challenged ground in rejection of plaint. If there is no locus standi, and for instance we can take here that it provides that the grounds which are abused leading to institution of suit, these grounds are not there only, that the locus standi should be relaxed and the suit cannot be brought about. Relief that is claimed is undervalued, you have not paid the proper valuation of that, court fees is pending, or if there is insufficient stamping of the documents, then you have to impound the documents, or else the plaint will not be accepted and rejected. Then the suit is barred by law. For instance, again, limitation law we can take into consideration here. A very commonly used ground for rejection of plaint again is suit barred by law. In that, if suppose any immoral activity is taking place and for that somebody has gone to the court, so we all remember that maxim, no one can go to the court without clean hands. So if his grievance is not based on moral policies, it is against immoral, it is actually supporting immoral activities or is illegal in itself, then that is barred by law. Or limitation is also a common example of that. So उस बेस पर आप आपकी प्लेंट रिजेक्ट करवा सकते हैं. The plaint is not filed in duplicate, but generally court does not favor this ground much, that just technical things we are taking into consideration. It can be ordered that the plaint copy is provided. Non-compliance with statutory provisions अगर है तो भी rejection of plaint का order pass हो सकता है. But again, as I told you, similar reason can be given here, that court is not inclined to give such kind of orders generally. What are the other grounds of rejection? If suppose signature is not there, that is also a technical ground. And if suppose the plaint is not showing a clear right to sue, the plaint is very vague. As we have discussed the fundamental rules of pleadings, that it has to be very specific and it should plead all the facts that are leading to a cause of action. Plaint can be rejected if suppose cause of action is not reflected, and it can also be rejected if the pleadings are very vague and not making any sense actually and not giving a clear picture. That can also be a ground for rejection of plaint. So rejection of plaint has an effect of what? Dismissing the suit altogether. In return of plaint it is not so. If we do a comparative analysis, this is what is the basic difference. Effect of dismissal of suit is what we can make out from rejection of plaint. Return of plaint is just you are filing that suit in other court, and that is the court which is the proper jurisdiction court. And in case of rejection of plaint, there are different consequences altogether. That is going to preclude the plaintiff to file a fresh suit on same cause of action also. He has to justify himself and his cause of action if suppose cause of action की basis पर plaint reject किया है तो. So rejection of plaint takes away the very basis of the suit itself and it actually dismisses it altogether. And in this case, order of dismissal of suit while recognizing the existence of a suit indicates the termination. Here one more interesting point has been raised actually, that अगर हम dismissal of suit करते हैं, so that is when the suit is going to extinguish by termination. But rejection of plaint is not like that. Rejection of plaint takes the very basis of the suit, rendering as if there was no suit at all. It will be treated as if there was no suit at all that was filed. It was not in existence. So this was all that we could discuss about rejection of plaint and return of plaint, and also the differences are clear as the concepts are altogether different, the processes are altogether different. So don't forget to subscribe to our YouTube channel, and also stay tuned as we are coming up with a free workshop of Robin Dutt sir, who is a senior counsel having experience of more than 25 years at the Punjab and Haryana High Court and the Honorable Supreme Court of India. So don't miss this workshop, as he will be guiding you all on career and litigation, judiciary and ADA. So don't forget to subscribe and prepare 50% faster with our exam B. Thank you.